Next, though, a private civil justice centre which operates outside of the court system has just been launched in Auckland. It provides independent dispute resolution services, an alternative to litigation through the courts, and will involve some of the country's top legal minds. What will it do and why is it needed at all? The director of the New Zealand Dispute Resolution Centre is John Green. He's a background in disputes resolution with the Building Disputes Tribunal and the Weathertight Homes Resolution Service. He joins us now on the line from Auckland. Thanks for being with us, John.
Good morning. My pleasure.
What will this tribunal do?
We'll help parties get disputes resolved promptly, cost-effectively and efficiently. One of the problems at the moment really is that the cost of litigation is just too high, and therefore those costs are a barrier to access to justice for all but the very wealthy and some major corporates and those on legal aid. And we can provide a very credible and professional alternative to parties to all kinds of civil and commercial disputes.
So it's the civil claims that someone suing someone over a failure to perform or a failure to fulfil a contract, that kind of thing that typically goes through the court system and at cost?
Yes, generally those types of disputes. We've got a specialist family and relationship mediation panel that specialises in mediating all kinds of disputes and conflicts that arise in relation to family matters and relationship disputes, whether they're personal or commercial.
It's interesting how the system works currently. You mentioned that. I thought we already had we certainly have the employment mediation service. We have the family court and a mediation service that sits beneath that. So at what level would people be coming to your service? At what sort of event in their life would they be coming to your service?
All kinds of events, really, and involving all amounts of money and all kinds of issues. People will come to us because they want an alternative dispute resolution process that's an alternative to litigation through the courts, and there's a number of reasons why they might choose to do that, and confidentiality is certainly an important aspect of private dispute resolution. A lot of parties don't want their business practices publicised or their purchasing and selling policies made available to competitors, and confidentiality protects the parties, and it's important for business.
Interesting on the relationship and family mediation front. Would this often come down to questions around finances, family trusts, that kind of thing?
Yes, all of those kinds of issues that present for parties when there is a breakup in a relationship of any kind. Once again, whether it's family or a commercial relationship.
Are the decisions binding, though?
Typically they are. In some cases, the parties can choose to opt for a non-binding decision to give them some guidance as to how the matter ought to be resolved or how it might be resolved if the matter were to be referred to the court or to arbitration. And in a lot of cases, parties choose mediation because they want a say in the outcome of that particular dispute for themselves.
If it's binding, how is it binding? If it's sitting outside of the court system, what law would apply? The law of contract, presumably.
Contract, yeah.
So if you both sign on the dotted line that you're agreeing to this deal, it then becomes very much under the umbrella of the justice system, the court system.
Yes, it does. It does. And for that reason, there will be times, of course, when the parties will need to refer matters to the court to rely on the coercive powers of the court to enforce the bargain that they've made.
Is it going to be cheaper than going through the courts? I'm thinking of something like the Small Claims Tribunal, typically low sums involved there, but by and large, is it going to be cheaper than going through the court or its allied systems?
Generally speaking, it will be cheaper. I mean, we'd never compete with the Small Claims Tribunal. That's a specialist tribunal set up specifically to deal with very low-value claims. But in larger commercial transactions, by and large, we can provide a very credible, very efficient, and very cost-effective alternative to the court system.
How can you save money on the court system?
Because time is money, and we can certainly deal with these matters a lot quicker than the courts are able to, and it's no criticism of the court. It's just really a reflection of the current environment, which I suppose is characterised by resource constraints due to increasing regulation and criminalisation of social and economic activity and expenditure of public money, and that's causing delay, uncertainty and cost for commercial parties.
Are some going to say, here we go, here's the privatisation of an element of the court or the legal system?
It's just an alternative. There will be cases that are not appropriate for private dispute resolution, and there's no question about that. But it's really just a question of giving parties to commercial contracts in particular and all other types of legal relationships an alternative means of resolving disputes that will inevitably arise.
There's some very big names in the legal system involved, an awful lot of QCs involved. What was the background to bringing this together, and what role do these QCs play in the system that you formed?
You're right. We've got some very, very capable people on board with us who are able to provide the dispute resolution services on a private basis. We have got a number of retired judges, QCs, from here and Australia and the UK, once again just to provide parties, commercial parties here with choice. They really are some very, very capable people.
This emerged how? There was a series of seminars, I understand, a couple of years ago that highlighted something of a crisis, I think the word was used.
There was a seminar series that was called Litigation and Crisis, and it sought to try and, establish the problems that presented for the legal profession and for the people who use their services, and to try and come up with some kind of solution, I suppose. And I guess the New Zealand Dispute Resolution Centre is in fact a solution for the very issues that were identified throughout those seminar series, and primarily the problems related to delay and cost.
These are vastly experienced, especially the New Zealanders, vastly experienced operators in our court system. Why are they saying the delays are as bad as they are? What's causing it?
Well, particularly in Auckland, I suppose, it's the increase in the P trials and other criminal trials, leaky building trials. I mean, they consume weeks and weeks of court time. And as a result, a lot of the commercial matters are simply pushed back. And the commercial people are saying that that's just not acceptable. It's not what they want. It's not what they need.
You mentioned, we mentioned your involvement in two major areas of resolution. One is building disputes and the other is the Weathertight Homes Resolution Service.
Yes.
Could you see this new centre picking up some of that work, or are they functioning as they ought independently and that's where people should go?
By and large, they're functioning fine. We can certainly provide a private alternative to those services. I mean, we already provide specialist dispute resolution services to the building and construction industry under the umbrella of the Building Disputes Tribunal, which has been around now for some 20 years. And we've certainly gained a lot of experience in providing private dispute resolution services through that, particularly in the design of innovative and creative dispute resolution processes, rules, agreements, protocols, and all of the other systems that need to underpin that service.
Thank you very much for your time. John Green, who is the director of the new New Zealand Dispute Resolution Centre, which was launched this week. It's a private civil justice service that operates outside of the court system and draws on the expertise of some of New Zealand, Australia and the UK's leading legal minds.